Hey everyone, welcome back to U.S. Immigration, where we break down immigration law without the legalese overload. Imagine this. You're building a life here in the U.S., kids in school, a job you love, and suddenly a deportation notice hits. Heart-stopping, right? But here's the good news. In 2025, under ramped-up enforcement from the Trump administration, there are proven defenses that can pause, fight, or even stop deportation entirely. We're talking asylum, family protections, and fresh court wins that could change everything. Today, we're diving into what defenses can stop deportation in 2025. This isn't just theory, it's actionable info with the latest updates. Stick around. Hit that like button if you're fighting for your future, and subscribe for weekly tips. Let's save some dreams starting now. Quick Deportation 101. First, a super quick primer. Deportation, aka removal, starts with a notice to appear from IC or DHS. You get a court date before an immigration judge. Without a defense, you could be out in weeks, especially with 2025's mass deportation push, where IC has already hit nearly 200,000 removals in the first half of the year alone. But here's the power move. At that hearing, you can fight back. The judge must tell you about relief options, if you qualify. Pro tip. Get a lawyer. ASAP stats show represented folks win 5x more often. Now, let's unpack the defenses. 1. Prove you're not removable. Defense numero uno. Challenge the charges. The government has to prove you're removable, not the other way around. If your NTA has errors like wrong dates or unproven claims, deny it all and watch them scramble. Eligibility. Any undocumented person. Just show up with docs proving inconsistencies. How to apply. At your first hearing, say contest boom, case it closed fast. 2025 update. With expedited removal spiking for new arrivals, this procedural fight is hotter than ever. A fresh advisory warns against rushed deportations for kids and families. Real talk. One client of mine dodged removal because IC botched the paperwork. You got this. 2. Asylum. If fear's your reality, asylum is your lifeline. Fled persecution based on race, religion, politics, or social group. You can stay, work legally, and even path to citizenship. Eligibility. Prove past harm or future fear file. Within 1 year of entry, exceptions apply. Process. Defensive asylum in court. Start with a credible fear interview if detained. 2025 twist. Amid Project 2025 asylum crackdowns, a federal judge just ruled for bond hearings to give detained folks a fair shot at this huge for families. Over 50,000 grants last year. Don't miss your window. 3. Withholding of removal in CAT. Not asylum eligible? Level up to withholding of removal, same idea. But you need to show it's more likely than not you'll face persecution back home. Convention against torture. If torture's a threat, no persecution link needed. Both let you stay and work, but no green card path. Eligibility. Higher proof bar than asylum. Great if bars like time limits block you. Process. File in court with evidence, affidavits, country reports. Fresh 2025 info. Enforcement's targeting third country deportations. But Supreme Court pause on due process rules means more hearings use it. 4. Cancellation of removal. Got deep U.S. roots? Cancellation could cancel your deportation if removal would wreck your U.S. citizen kid, spouse, or parent with exceptional hardship. Eligibility. 10 plus years here. Good moral character. No big crimes. Process. Submit Form EOJAR 42B in court. Prove hardship with docs, school records, medical bills. 2025 alert. Fee hikes from the big, beautiful bill. Just jacked up cost, budget $675 plus now, but nonprofits can help waive. Wins lead to green card's family game changer. 5. Adjustment of status and U visa. Married to a U.S. citizen? Family-based adjustment swaps your status for a green card, but you need legal entry. Waivers possible. Crime victim? U visa for cooperating with cops on serious offenses. Eligibility. Ties to U.S. family or victim status plus helpful info to law enforcement. Process. File I-45 or I-918 in court. Hot tip for 2025. voluntary self-deportation programs offering stipends to leave on your terms, but only if no better defense fits. Bonus defenses and 2025 wildcards. Quick hits. VAWA for abuse survivors, self-petition like cancellation. Voluntary departure, to leave clean and return later. Or push for prosecutorial discretion. IC might drop your case if you're low priority. 2025 Shake UPS. New registration form G 325 could snag unregistered folks. Talk to a lawyer before April deadlines. And TPS extensions for countries like Venezuela are holding strong against deportation waves. Folks, deportation's scary, but knowledge is your shield. These defenses have saved thousands. They could save you. Remember, this isn't legal advice. Consult an immigration attorney or free clinic today. Drop a comment. What's your biggest question? Like if this helped, share with a friend in need, and subscribe for more 2025 updates.